I don't have time in 3 minutes to explain my arguments here. So I encourage the members, please ask me to expand on the points that I'm about to make. This legislation is void for vagueness, and it smacks of due process violations. The void for vagueness doctrine is this: a man ought to know what a man ought not do. And please ask me to explain why this legislation or bill is void for vagueness. Prosecutorial evidence under this proposed legislation is inadmissible under the fruit of the poisonous tree doctrine. And that metaphor is this: if the evidential tree is tainted, so is its fruit. And the entire tree giving rise to prosecution under this legislation is tainted, and it is repugnant to Tennessee Constitution, Article 1, Section 6, 7, 8, and 9, and Article 11, Section 16. Ask me why this legislation, prosecution under it, is fruit of the poisonous tree. And this bill craves to be amended to add defense from prosecution. Please ask me how this bill should be amended. And government needs to get its own house in order before it starts prosecuting the family of children involved in DCS cases. Children in custody of DCS are sleeping on floors in offices and in hotel rooms. Children are sexually and physically abused while in state custody. And DCS is literally the principal pipeline for pornography, child trafficking, and prostitution. Let's fix and prove reform of DCS before we start prosecuting families that are harboring children from DCS. If DCS were subjected to the same level of scrutiny that parents are subjected to, every child in custody of the state would be removed, and that is a fact. It was agreed in our Declaration of Independence. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out our substance. And more often than not, that's what DCS is: swarms of officers harassing our people. In 2020, the Physicians for Human Rights stated that forcibly removing children from parents causes catastrophic physical and psychological damage to the brains of children. And when DCS is taking children, more often than not, they are causing more harm than the alleged neglect. The fact that DCS cases are almost never criminally prosecuted is proof that these cases are primarily for what they call neglect or other reasons. And the courts and DCS can make these reasons to be whatever they want to be. And this bill desires to criminalize parents for protecting children from a broken and corrupt system. Representative Travis, I respect you. Please take this bill off the calendar. And for the members of committee, please ask me, what is void for vagueness? What is fruit of the poisonous tree? How would I amend this? Please ask me why this is in violation of the state constitution. Ask me to clarify my points. Thank you for your honor, for your time, committee, and I would appreciate any questions from the members.
Thank you, Mr. Gentry. You have questions for Mr. Gentry? The exclusionary rule, yes, sir. Go ahead, Mr. Fritz.
Thank you, Mr. Chairman. I've got to ask you, the fruit of the poisonous tree, give me 2 minutes on that, please.
Okay. On fruit of the poisonous tree, Tennessee Constitution, Article 1, Section 6, the right of trial by jury shall forever remain inviolate. And parents having custody removed from DCS, 100% of these cases across the board, without exception, are removed without the benefit of trial by jury. Whenever there is a fundamental liberty interest at stake, like the God-given right to parent one's children, there should be a mandatory trial by jury. Article 1, Section 7, people shall be secure in their persons from unreasonable searches and seizures and general warrants without evidence of the fact, and whose offenses are not particularly described and supported by evidence, are dangerous to liberty and ought not be granted. And since reports to DCS can be anonymous, the offenses are almost always not particularly described, and they're never supported by evidence. And because DCS conducts interviews in our schools without notice to the parents, the people are not secure in their persons, and they're subject to illegal and unreasonable searches. And here's the most important one. Article 1, Section 8. No man shall be disseised of his freehold liberties or privileges, or in any manner destroyed or deprived of his life, liberty, or property by judgment of his peers or law of the land. And parents are deprived without judgment by their peers, and they are deprived without law of the land. You know, when you look at these reasons that children are removed by DCS, I mean, and I can go into this. We look at some of the reasons. I downloaded this from DCS website: environmental neglect, leaking gas from a stove, structural hazards such as caving in roof or holes in the walls, children that lack clothing, open windows, broken windows, like literally open windows. They can remove your children. That is not law of the land. That is policy from DCS. And so these removals are occurring in express violation of Article 1, Section 8, and Article 1, Section 9 about criminal prosecutions, that you have a right to face your accusations and to meet witnesses face to face. And because these accusations are anonymous, you can't meet them face to face. Because these are conducted in civil court and not criminal court, you're deprived the right to a trial by jury. The whole thing is fruit of the poisonous tree, because the entire process is occurring in gross violation of our state constitution. And there's a reason that the framers put this in here. And that's why they said law of the land or judgment by the peers, because they knew the British ministry was making policy just like our DCS department is today.
Okay, Mr. Gentry, that's well past the 2-minute mark. Any other questions for Mr. Gentry? Yes, sir. Chairman Doggett.
Thank you, Mr. Chairman, and thank you, all of you, for being here today. I didn't know who all was going to be on the list, and so I'm going to direct my question at you because you're here. But last week in the subcommittee, it was brought up that this entire bill was built around anonymous reporting. I spent all weekend trying to do research on this and try to find that. Can anyone show me where that is in correlation with this bill?
Mr. Gentry, can you address that question?
So how does this anonymous, well, technically they're confidential, not anonymous. So the accused never gets to meet the person, who's making the allegation against them. But where this breaks down at is this whole process, very often it's false and unsupported allegations. So now how does this play out to the bill? Well, if you've got a broken process and literally a very corrupt process going on where citizens are being literally harassed by attorneys for DCS, the case managers from DCS, they're forced to go through all these ridiculous hoops that takes them 2 years to go through, while they're bowing to the will trying to get their kids back. This entire process is all so broken that when it gets to, that custody is removed and there's in DCS custody, when it gets to that point, you're going after a person who's been maliciously prosecuted by a person that they never get to know who made the allegation. So this is the problem why all of this, and as I mentioned, why the whole process is unconstitutional. And so, it's fruit of the poisonous tree. You've got a broken down process that results in a DCS custody order, And then the person, whether they know about the order or not, because it's void for vagueness, the bill says knowing. And then I know in subcommittee they said, well, knowing is defined in the definition section. No, it's not. It says knowing means a person who acts knowingly. You can't define a word with the same word. It's stupid. It's tricky, deceptive attorney language in that definition that you don't know what it means. And then it says, and then it goes on in that definition saying that they know that the act will cause a result. And that's like, if you put a round in a chamber and you pull the trigger after pointing it at somebody's head, the result is they're probably going to be dead. You know that. But what's the result of harboring a child from custody from an agency that is absolutely broke and corrupt? And so I hope that answers your question, Representative Doggett. The way this anonymous plays in, they never get to meet their accuser. And the whole process plays out, and custody is removed under an entirely unlawful process that's repugnant to our state constitution. And now you're going to prosecute them criminally with a Class E felony subject to 1 to 6 years in prison. And how is that going to help the kids? What if mom gets a custody order and she goes and drops the kid off with grandma? Maybe grandma knows. We don't know from the definition. And what, are they going to send grandma to jail for this? Stop this legislation. It is absolutely ridiculous that we're going to process when we can't even keep their own house in order in DCS. And I have literally seen, I have personally witnessed these things where they refuse to uphold rights, like a parent wanting to video record the interview. And the DCS worker and their supervisor's like, you can't record it. Why can't you record it? They want to conduct star chamber proceedings so that they can make false and unsupported allegations. This whole thing is about money. Each of these kids gets taken into custody. They're worth tens of thousands of dollars to the state government. It's in the budget. They're getting hundreds of thousands. Probably many millions of dollars are coming from the federal government in Title IV incentive money to reimburse the state for foster care. But they get more than dollar for dollar reimbursement. It's a profit center. And that's why this is happening, is because it's a profit center for this department and for the state. And it also results in litigation. And so parents got to hire attorneys. Attorneys are getting paid. Case managers are getting paid. Everybody's happy. And it is catastrophically causing physical and psychological damage to the brains of children in the midtime. And now we're going to criminalize people that are trying to protect their kids from this process. So I hope that answered your question, Representative Doggett.
I thought 2 years ago we addressed the confidential reporting, that it was legislation that I carried, that we had a summer study over, and then we come back with some language that put you, if you were accused, I believe, I've seen a lot of bills and read a lot of bills over the last 3 months, but my memory may be slipping. But I thought there was a time when you had due process, that you were in court in front of a judge during this, in any hearing that was going to be an ex parte or anything of that nature that was going to take the children out of your home. I'm trying to link the confidential reporting to this bill because it says knowing. I would think that based off of that legislation from 2 years ago, that someone would know because they were there in the hearing and knew that their child was being taken, it was going into DCS custody. That's what I'm trying to figure out. I'm trying to bring all these. I know we're saying a lot of things, and there's a lot of emotion and passion, and I feel you. I'm right there with you. I'm just trying to corral all this down and kind of hone in and focus on this and see if I can tie the direct correlation between confidential reporting and this bill and how the two are connected or intertwined.
Well, with the confidential or anonymous reporting that goes on, people can make up whatever they want, and these reports a doctor is recommending care a parent doesn't agree with. So he reports them to CPS, dentists, teachers, school psychologists, and I have personally witnessed this, that they just make up whatever allegations. And then they go in and they get an ex parte order. You talk about new legislation. They just came out with legislation. Typically, these cases are reviewed by a magistrate who is not a judge in juvenile court. And we're looking at legislation now that whenever you get a decision from a magistrate, you can motion for court review. You say, I don't accept this magistrate's order. I want a real judge to rule on it. And the existing process under that is that the court, the real judge, reviews the case de novo from the beginning as new. Now they're making it, and they're changing this, that the court review can occur that there's a presumption of correctness from the magistrate. We're going to assume that the magistrate, who's not a judge, is correct in this juvenile case. And again, this is all happening without benefit to trial by jury. When you look at Miranda v. Arizona, everybody knows that case. You're denied due process if you're not advised of your right and you're not warned of the consequences. Here's what should happen. You have a right to a trial by jury. If you waive your right to a trial by jury, you may be subjected to a corrupt, biased judge who will not rule according to the facts and the law, but will rule according to his own pecuniary interests. Do you wish to waive your right to trial by jury? What sane person would? Confront adverse testimony face to face. The people don't even know what due process is and that their constitutional rights are being violated. I wouldn't get hung up on the anonymous part of this. The entire process is repugnant to our state constitution. And so if you've got custody transferred to DCS under an unconstitutional process, and then you want to criminally prosecute somebody with a Class E felony, 1 to 6 years. I don't know how we can do that in good conscience. And I know that the members here, many of you, I know, stand behind the Constitution and you stand behind the rights of the people. Let's fix our house first before we start trying to put more people in jail and subject them to more corrupt court proceedings.
Okay. Chairman, you...
I'm sorry, I don't know that I got the answer to my question. I don't know if legal services can...
I have my ADA rep here. Can she have 1 minute? Because my wife doesn't want to speak now.
She spoke in the sub, and so that rules out speaking here.
But I'm just trying to answer the question. He said he didn't get an answer. And I have one. I use my ADA rep back and forth to come up with what I need.
Okay, I understand.
I have a traumatic brain injury. I apologize. Would that be okay?
That's fine with me. We need to wind this up, though.
You're allowed to speak for. I can't get out what I told you I wanted.
Just one last comment on that, Representative Doggett, is, these allegations as being, confidential or anonymous, and then it goes to an ex parte order, and the children are removed under these ex parte orders. And, these parents, very often, they haven't done anything, and it's certainly not law of the land. There's no law out there that says that you have to accept the medical advice of a medical professional. There's nothing in the statute that says it is neglect. In fact, neglect is not even defined in Tennessee Code Annotated. It is not defined. And what neglect is what CPS policy says neglect is. There's literally, and so that's in direct violation of Article 1, Section 8. And then you're going to criminally prosecute somebody for that. It just doesn't make sense. But because these are going to ex parte orders, and that it's based on confidential process, the whole thing just breaks down from there. You know, how do you defend yourself? And then when you do get to hearing, you never get to confront the person who made the allegation against you. You don't even know what they are. Yep.
Could have cut them off in the parking lot.
Sorry, I missed that.
Okay, any other questions? And we'll go back in session. All right, thank you folks for being here.
Thank you, Mr. Chair.
We're back in session.